Hi, my name is Eric Willis, and I'm an attorney licensed to practice in the state of Ohio. And that's the first caveat I'll get you, is that you should not be taking this as legal advice if you are outside of the state of Ohio. Different states' laws are different when it comes to Ohio, when it comes to landlord-tenant law. And some states are very similar to Ohio, some states are not. So if you are a landlord or a tenant in Ohio, then this information is for you. Now, note that I called it information. I did not call it legal advice, and that is because I am not your attorney. I've never met you. I don't know the facts of your individual case. How could I be your attorney? The only way I could be your attorney is if you called me and we decided that I would be your attorney together. So please treat this video as for informational purposes only, and as far as the state of Ohio goes, not any other state. We're going to be talking about defenses to evictions. As we said in previous videos, there are three types of defenses. There are fact defenses or merit defenses. There are legal defenses, and then there are procedural defenses. We're going to talk about one that's a bit of a mixture of legal and fact. And that is called the Estoppel Defense that tenants have to an eviction. Now let's picture a situation where the lease says that the rent must be paid on the first of every month. But sometimes the tenant pays on the first, sometimes the tenant pays on the 5th, sometimes on the 8th, once or twice on the 10th or the 15th, then back to the 1st again, maybe next month to the 3rd. Just always sort of a scattershot range of paying the rent late. And every time the landlord gets the rent late, whether it be 1 day late or 5 days late or 2 months late, eventually the tenant, let's say, catches up. But whenever the landlord gets the rent late, the problem is that the landlord takes the rent and deposits it without protest. Well, at some point, maybe the landlord gets a little tired of late rent, and come July, the rent's not paid by the 2nd, and so on the 3rd of July, the landlord puts a 3-day notice to vacate on the door. The tenant comes running with the rent the very next day, even though it's July 4th, and the landlord says, sorry, not accepting any late rent. I'm sick of you. You've been late so many times. It's been like 12 or 13 or 14 times you've been late, and I'm just not going to accept the rent. We're going to go through with the eviction. Well, what's going to happen is, if the tenant knows the tenant's rights, or if the tenant comes across an attorney who knows landlord-tenant law pretty well, is you're going to get what's called the Estoppel Defense. And what an Estoppel Defense is basically an affirmative defense where the tenant alleges that the landlord and the tenant have engaged in a course of conduct that is contrary to the strict terms, in this case the prompt payment clause of the lease, the strict terms of the lease, and it's happened over and over and over again, so often that it's come to the point where the tenant has come to justifiably rely on the fact that paying the rent late every now and then, over and over even, it's not that big a deal because the landlord does not raise a stink about it. And if that course of conduct is established by the tenant, and that's where it becomes sort of a factual defense, maybe the tenant can show checks that are dated on the 8th, checks that were dated on the 10th, checks that were dated on the 15th, and every time those checks were cashed by the landlord. If the tenant can show that over and over and over again, and perversely, the more the better. If it's only been 1 or 2 late times and the landlord hasn't cared, that might not be enough of a pattern of conduct to establish estoppel. But you start getting into 4, 5, 6, and more, where the tenant pays late and the landlord doesn't seem to care, then you've got that estoppel defense. And you know what that means? Case dismissed. Now, how do we get out of this estoppel problem once it's started? And what happens there is, let's go back to our same example with the tenant who pays late all the time and the landlord who accepts it without protest. So long as the landlord, after growing tired of the rent being late, let's say it's July 2nd, and instead of putting a 3-day notice on the door, instead the landlord puts a notice of strict compliance on the door. Now, this doesn't have to be worded in any special way, like a 3-day would in Ohio. It just has to be a letter or a note, something in writing from the landlord to the tenant saying, "Dear tenant, in the past you've paid rent late. I've accepted it. That's all fine and good. But from now on, starting next month, I need the rent paid on time, every time." Now the landlord has put the tenant on notice that the past course of conduct can no longer be relied upon. If the landlord does that, then the estoppel defense will not work, and the landlord's case will not be dismissed.